A House bill concerning email privacy passed unanimously yesterday, highlighting that current laws are outdated and allow for government overreach when dealing with information stored on the cloud. Supporters of the bill consider this a historic step toward updating privacy laws for the digital age. So this bill that passed is called the Email Privacy Act. It was, as I said, voted through unanimously with 419 to 0. That includes 238 Republicans as well as 181 Democrats who were voting. So that's an interesting thing, just the fact that there was such a bipartisan support of this bill, and it was co-sponsored by more than 300 House members, and it's the basic tenet is that it requires law enforcement to seek a warrant if they want to ask any tech companies for access to people's emails or any online documents. For example, that includes photos, any documents that have been stored on the cloud. And it's regarding information that is over 180 days old. So as of now, the Justice Department and the Securities Exchange Commission, they only need a subpoena. And this is as a result of a 1986 piece of legislation called the Electronic Communications Privacy Act, which was, during the Reagan era. It was written before the internet and before so much of our information was stored online. So the supporters of this bill are basically saying that act, the Email Privacy Act, or I'm sorry, the original 1986 Act, just did not take into account the internet and what that will do. So what do you think immediately?
Oh, that this is so magnanimous of them to finally be protecting the Fourth Amendment right when it comes to our emails. Somewhat. Look, the SEC, they admitted in 2010 to using this loophole in this 1986 ECPA Act to be able to access people's emails and go way back. 1986, there was no cloud, there was no storage.
Exactly.
Servers weren't capable of storing everybody's electronic communication like they are now. The fact that they've been circumventing people's privacy rights for this long, though, it's like they're all finally on board.
Yeah.
They don't want their emails read. Of course, it's a bipartisan support. Who would be against this?
Exactly. Like I said, I mean, that's what was so compelling about the stories is how from folks from both sides of the aisle are supportive of this. Of course, we've seen, Edward Snowden was a huge whistleblower when it comes to government surveillance of emails and online documents. Whether you agree that he's a traitor or whether you agree that he's a hero, I think it still kind of shook people up of just knowing how arbitrary it was that the government is searching documents left, right, and sideways. Then, of course, we have the issue with Apple and FBI, the FBI trying to get them to hack into the San Bernardino shooter's iPhone. I did a story a couple of weeks ago about how Microsoft filed a lawsuit against the government for similar reasons of wanting to be able to notify users if the government wants to look through their stuff. So I think everybody's just sort of getting on board with the fact that they're not saying that the government can't look into your stuff. It's just
making it harder.
Yeah.
The subpoena versus warrant argument, they're making it more difficult for these officials. And look, just taking this back to Snowden for a second, because he's the reason that we're talking about this. He opened up the international dialogue when it comes to privacy rights and what the government's doing. I happen to think he is a hero. He falls on the right side of history for me. But we're still, this is 2016, so he came out with this information 3 years ago, just around 3 years ago, and our laws are just now sort of scratching the surface, just a little. It's like, oh.
Yeah, absolutely. So, and one thing to consider, though, too, is even with this bill, the portion that requires the government to let users know if they're going to be seeking a warrant, that was actually taken out of it. So some people are a little bit bummed that was taken out, but it's still a very decent step. So for example, a person that was part of the writing of this. So Sophia Pope, she's a staff attorney with the Electronic Frontier Foundation. That's a nonprofit organization that defends civil liberties with regards to just the digital world. She had this to say. She says, while we applaud the passage of H.R. 699, the bill isn't perfect. In particular, the Email Privacy Act doesn't require the government to notify users when it seeks their online data from service providers, a vital safeguard ensuring users can obtain legal counsel to fight for their rights. However, companies may continue to provide notice to users of government requests prior to compliance, something many companies commit to in our annual Who Has Your Back report. So yeah, again, it's not perfect, but I think it really is just catching up. So the companies don't they can choose whether or not that they want to let you know if Big Brother is watching you. So this bill, it's unclear whether or not it's going to immediately pass in the Senate. Obviously, this unanimous support in the House is going to add pressure to the upper chamber to approve that. More than a quarter of senators have endorsed similar legislation. One thing to consider, though, is that the SEC has lobbied against similar legislation because they say that it would make it harder for law enforcement to deal with securities fraud. But again, I think it really broadens the debate, and at the very least, it's a very important step towards ensuring our digital privacy.